5 seconds to go. Start. It is also trite that a court should not be overzealous in searching for ambiguities or obscurities in words which are plain. So far as the provisions contained in Section 7 of the POCSO Act are concerned, the court does not find any ambiguity or obscurity so as to invoke the rule of lenity. In the light of the afore discussed legal position, if the findings recorded by the High Court are appreciated, it clearly emerges that the High Court fell into error in case of the accused Satish in holding him guilty for the minor offences under sections 342 and 354 of IPC and acquitting him for the offence under section 8 of the POCSO Act. The High Court, while specifically accepting the consistent versions of the victim and her mother, that is informant, about the accused having taken the victim to his house, having pressed the breast of the victim, having attempted to remove her salwar and pressing her mouth, had committed gross error in holding that the act of pressing of breast of the child aged 12 years in absence of any specific details as to whether the top was removed or whether he inserted his hands inside the top and pressed her breast would not fall in the definition of sexual assault and would fall within the definition of offence under section 354 of the IPC. The High Court further erred in holding that there was no offence since there was no direct physical contact, that is, skin to skin with sexual intent. The interpretation of section 7 at the instance of the High Court on the premise of the principle of ajus dam generis is also thoroughly misconceived. It may be noted that the principle of ajus dam generis should be applied only as an aid to the construction of the statute. It should not be applied where it would defeat the very legislative intent. As per the settled legal position, if the specific words used in this section exhaust a clause, it has to be construed that the legislative intent was to use the general word beyond the class denoted by the specific words. So far as section 7 of the POCSO Act is concerned, the first part thereof exhausts a class of act of sexual assault using specific words, and the other part uses the general act beyond the class denoted by the specific words. In other words, whoever with sexual intent touches the vagina, penis, anus, or breast of the child or makes the child touch the vagina, penis, anus, or breast of such person or any other person would be committing an offense of sexual assault. Similarly, whoever does any other act with sexual intent which involves physical contact without penetration would also be committing the offense of sexual assault under Section 7 of the POCSO Act. In view of the discussion made earlier, the prosecution was not required to prove a skin to skin contact for the purpose of proving the charge of sexual assault under Section 7 of the Act. Stop.